School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 6 Business and Sustainability Unit 13 Competition Law Part 2.
Relevant market. Under the statutory framework of the Competition Act, the delineation of relevant market is of utmost significance. For an abuse of dominance investigation, an enterprise shall be considered dominant only if it has attained a position of strength in the relevant market. Determination of a relevant market is also significant in a combination analysis where the CCI has to ensure that the proposed combination does not result in appreciable adverse effect on competition. In the case of Competition Commission of India, that is CCI versus Coordination Committee of Artists and Technicians of West Bengal Film and Television Industry, the Supreme Court had held that the delineation of relevant market is not a necessary precondition for investigations under Section 3 of the Act, as there is a presumption of AAEC in an agreement between market participants under that provision. Relevant market may be determined by the CCI with respect to the relevant product market or the relevant geographic market or with regards to both. Relevant product market is referred to as a market with products or services considered interchangeable or substitutable by a consumer due to factors such as characteristics of the products, price, or use. In the case of InRematrimony.com and Google was charged with abusing its dominant position by granting preference to its own services and its verticals by manipulating the search results. The relevant market in this case was delineated to be the market for online web search services in India and the market for online search advertising in India. This was done by differentiating between offline and online sections of advertising on the basis that they are not substitutable. Relevant geographic market is referred to a market comprising the area where the conditions of competition for supply of goods or provision of services are distinctly homogeneous and can be differentiated from the conditions existing in the adjacent areas. In Harshita Chawla and others, since conditions for the functionality of OTT messaging apps through smartphones were found to be homogeneous throughout India, the entire geographic area of India was delineated to be the relevant geographic market. Abuse of dominance. Under competition law, mere dominance exerted by a firm is neither considered bad nor held punishable. However, the abuse of its dominance by an enterprise merits investigation by the competition authorities. This is in contrast with the earlier legislative framework as under the erstwhile MRTP Act, where violation was gauged based on the size of an enterprise rather than the abusive conduct of the latter. An enterprise is said to be in a dominant position when it is able to operate independent of other competitive forces existing in the relevant market and has the power to affect the consumers or its competitors in its favor. Competition law makes abuse of dominance by an enterprise punishable under law. Some of the acts considered to be an abuse of dominant position includes imposing of conditions or prices which are unfair or discriminatory either through direct or indirect means, which includes price discrimination and predatory pricing, and restricting the production of goods or provision of services. The Commission seeks to capture conduct which may be exploitative, wherein the acts of the enterprise prove detrimental to the consumers in the form of rise in prices, reducing output, or imposition of other unfair terms and conditions, and exclusionary, that is, affecting the competitors of the dominant firm through the acts of exclusive dealing, margin squeezing, denying market entry, etc., to name a few. In the case of European Union versus Google, also known as Google Search Shopping case, Google was fined 2.42 billion euros by the European Commission for abusing its dominance in the general search market and stifling market competition by granting primacy to its own vertical comparison shopping services. It was held that Google's self-preferencing conduct had foreclosed competition in the shopping services market, which represented a separate market from the search market. Leveraging its position in the general search market, Google had resorted to bumping down other rival sites down the list, distorting competition. The three important steps required in every abuse of dominance investigation are: number 1, determination of the relevant market; number 2, determining if the enterprise is dominant in the relevant market; and number 3, if found dominant, investigating whether the dominant entity has engaged in acts falling under the purview of abuse of dominance. The CCI, while inquiring into the dominance of an enterprise, shall consider the factors provided under Section 19, Clause 4 of the Competition Act, which include market share, size, and resources, countervailing buyer power, market structure, and dependence of consumers. Section 4 of the Indian Competition Act also takes into account the use of dominance in one market to enter into another relevant market. In the case of Harshita Chawla and WhatsApp, the issue was whether WhatsApp was using its dominance in the relevant market of internet-based instant messaging apps to gain entry into another relevant market, being Unified Payments Interface or UPI digital payments app market, that is WhatsApp Pay, which was aided by pre-installation of WhatsApp on mobile phones. The Commission post-investigation held that there was no abuse of dominance as the users were allowed discretion before usage of the payment app, along with separate registration requirements and terms and conditions prior to initiation of services. Mergers and combinations. One of the significant business developments in the field of corporate law has been a plethora of transactions encompassing mergers and acquisitions. The rationale behind companies opting to merge may range from increasing market power, economies of scope, economies of scale, synergistic gains, eliminating competition, obtaining access to R&D, and technological know-how. Competition law is entrusted with the task of scrutinizing mergers that have a potential for undermining competition. While assessing a merger, the competition authorities investigate if the merger will generate horizontal effects, that is, effects born out of mergers between actual or potential competitors at the same level of the production chain and dealing with the same product or geographic markets; vertical effects, that is, effects occurring as a result of merger between enterprises operating in different albeit complementary stages or levels in the market for the same final product, or conglomerate effects, that is, effects originating due to mergers which is neither functionally vertical or horizontal but enables the merged entity to foreclose competition in two distinct but related or unrelated markets by exercise of its market power. Merger control as a means to keep a check on the market power of dominant firms on an ex ante basis is essential to preserve competitive market structures and for achieving pro-competitive effects for the consumers. A complicated element of merger control is that its role is forward-looking in nature, focusing on whether a proposed merger will lead to detrimental effects on competition in the future. Numerous theories of competitive harm have been brought forth to highlight the negative impact of a merger on consumer welfare, which includes unilateral effects, that is, resulting entity of a merger exercising market power post-merger, coordinated effects, that is, resulting entity of a merger able to harmonize competitive behavior with other firms in the market, vertical effects, and conglomerate effects. Competition authorities conduct merger assessment by weighing the pro-competitive effects of a combination on the market against the anti-competitive ramifications if the merger is allowed to be consummated. Under the Indian Competition Act, Section 5 and 6 are the significant provisions regulating combinations encompassing corporate restructuring methods such as mergers, acquisitions, and amalgamations. According to these provisions, enterprises or persons choosing to enter into combinations crossing the specified assets or turnover thresholds mentioned in Section 5 have to inform the CCI divulging the details of the proposed combination. A combination likely to result in an AAEC within the relevant market shall be void in accordance with Section 6. The various factors providing guidance to the Commission for approving or rejecting a combination are given under Section 20, Clause 4 of the Competition Act and includes factors such as extent of barriers to entry, the extent of countervailing power present in the market, market share of the enterprise, the presence of substitutes, etc. The notifications are handled with reference to procedure in regard to the transaction of business relating to Combinations Regulations 2011. Within 210 days after the notification of the proposed combination gets served, the CCI performs analysis if the combination causes or is likely to cause an appreciable adverse effect on competition, or AAEC, which is done based on the factors enlisted under Section 2, Clause 4 of the Competition Act. The Commission can approve a combination to take effect if found not to be causing an AAEC or disallow otherwise. The assessment of significant AAEC that may arise as a result of a combination and the subsequent decision in case of the former can also be assuaged by remedies or notifications termed as modifications. Under the Act, modifications may be suggested by the CCI or the parties, who can also propose changes to the suggested modifications in order to bring about a mutually workable feature within the specified time. Merger modifications, rather than outright rejections, is slowly gaining momentum for resolving combination issues threatening to disturb the status quo in the market framework. For instance, in Abbott Laboratories and St. Jude Medical Inc., A proposed combination was notified to the CCI under Section 6, Clause 2 of the Competition Act 2002 between Abbott Laboratories and St. Jude Medical Inc., that is SGM. Abbott dealt in manufacture, sale, and research of global healthcare products. SJM, on the other hand, is a global medical device company in the United States engaged in the production, development, and research of cardiovascular medical devices. It was observed that the functions of both the parties intersected in the manufacture of small hole VCDs. VCDs are healthcare devices used in covering the holes arising out of the arteries. As a result of the combination, the market share of the combined entity would be elevated to around 90 to 100% in the small hole segment, and the other active competitor would only have a market share of 5%. The entities proposed a voluntary modification by agreeing to engage in a divestiture involving the small hole VCD segment of SJM to Terumo Corporation, a third-party provider of cardiovascular products based in Japan, not having any structural or financial linkages with the parties on a worldwide scale, and this was approved by the CCI. Also, one of the recent developments in the area of combinations is the advent of green channel for combinations that are unlikely to have any anti-competitive effects in the relevant market. The merging parties, based on their self-assessment, specified criteria, and subsequent consultation with the Commission, may qualify for green channel and, after notifying the CCI, may consummate their combination through an automatic approval, whereby they may avoid the 210-day statutory standstill period. An example for a transaction that has taken the green channel route is the acquisition of Dodla Dairy Limited, a public limited company engaged in sale and processing of milk and milk products, by Industrial Finance Corporation, that is IFC, a multilateral finance institution under Section 6, Clause 2, read with Section 5, Clause AIA of the Competition Act. Since the proposed combination was not likely to result in any AAEC concerns, the relevant market definition was kept open. After ensuring that the acquirer was not engaged in any activities of the production, distribution, etc., which were similar to that of the target, the combination was given a go-ahead under the green channel route. Interestingly, when it comes to digital platforms, the conventional methods employed to assess anti-competitive effects may fall short. With the advent of big data, strong network effects, and the significance of personal data in the digital ecosystems, relying on traditional thresholds for gauging market power may not yield fruitful results. Different jurisdictions have opened up investigations to ensure that dominant online platforms do not engage in anti-competitive practices. The European Commission had initiated a formal antitrust investigation to unearth if Amazon's utilization of sensitive data obtained from independent retailers doing business in its marketplace is in contravention of EU competition rules. The CCI has also acknowledged the dual role played by data as an input and as a currency for monetizing services while investigating abuse of dominance and combination cases. In re-updated terms of service and privacy policy for WhatsApp users and WhatsApp LLC and Facebook, the CCI stated that factors such as innovation, customer service and quality have been elevated as non-price parameters of competition on the basis of which market participants compete. Recently, a probe conducted by CCI found tech giant Google guilty of stifling competition and engaging in practices leading to denial of market access to extend its dominance in services such as browser, search, app library, among others, for ensuring that its services serve as default options for achieving highest user preference. There have been calls in multiple jurisdictions to revisit the traditional thresholds in accordance with challenges posed in the digital markets. The Competition Law Review Committee has also recommended inclusion of data deals as one of the thresholds to be employed during merger control. Enforcement of competition law. The Competition Act also provides a multi-tiered enforcement mechanism. As per the provisions of the Competition Act, the Commission can inquire into alleged infringement of Section 3 Clause 1 or Section 4 Clause 1 of the Competition Act based on its own motion or on the receipt of any information or by a reference received from the central government, state government, or any statutory authority. Under the statute, there is no locus standi requirement. The CCI, after the receipt of the information, is expected to satisfy itself as to the existence of a prima facie case and pass directions to the Director General under Section 26, Clause 1 for initiating investigation. Director General. The Director General or the DG is duty bound to assist the Commission whilst conducting investigation for infringement of any provisions, rules or regulations made under the Competition Act, for which the DG shall be empowered with all the powers that are conferred on the Commission by the Act. Where the Commission considers that a prima facie case exists, it directs the DG to investigate the matter. In Excel Crop Care Limited versus Competition Commission of India and another, the Supreme Court held that an investigation by the DG must cover all the relevant facts and evidence in order to assess any anti-competitive conduct complained of. The court held that, and I quote, "The starting point of the inquiry would be the allegations contained in the complaint, but during the course of the investigation, if other facts also get revealed and are brought to light, the DG would be well within his powers to include those as well in his report." Unquote. Competition Commission of India or CCI. The Director General shall, after conducting investigation, submit his findings to the Commission. The Commission, based on the findings of the DG, may either choose to close the matter and pass such orders as it deems fit if no contravention of the provision of the Act is found, or call for further investigation if required. The Competition Commission of India, being the statutory regulatory authority entrusted to promote and sustain competition in the markets in India, is empowered to issue interim orders in the course of inquiry to prevent acts that may have an appreciable adverse effect on competition or culminates in the abuse of dominance by a group or an enterprise. The Commission also has the power to impose penalties for non-compliance with the directions of Commission and the Director General and for failing to provide adequate information on combinations when sought by the CCI. Aside from the power to impose penalties for omission, willful alteration or furnishing a false statement before the Commission. The CCI also has the power to impose lesser penalty on a person included in a cartel, provided he makes a full disclosure regarding the violations. However, it needs to be noted that this feature of imposing lesser penalty shall not be available if the investigation report pertaining to the cartel has been received from the Director General by the Commission before making of such disclosure. The CCI is also required to provide its opinion to the government in the formulation of competition policy. Appellate authorities. The National Company Law Appellate Tribunal or NCLAT has been designated as the appellate tribunal for handling the appeals arising from the CCI. The appellate body has been empowered to hear and dispose of appeals against any order, direction or decision issued by the CCI. Additionally, the NCLAT has been empowered to adjudicate on claims for compensation arising from the findings of the Commission as well as passing of orders for the recovery of compensation. The appellate tribunal, after providing parties to the appeal an opportunity of being heard, is empowered to pass orders modifying, affirming, or setting aside the decision, direction, or order appealed against. The appellate tribunal need not be bound by the Code of Civil Procedure 1908 but must conform to the principles of natural justice while conducting its procedure. The tribunal shall be vested with all the powers that are vested in a civil court for performing its functions during the trial of suit. Appeals from the appellate tribunal shall lie to the Supreme Court, which needs to be filed within 60 days from the date of communication of the decision or order passed by the appellate tribunal. Now let's summarize the unit. Competition law is an economic legislation of immense significance and plays an important role in managing the dynamics of the market. The provisions related to anti-competitive arguments, abuse of dominance, and combinations help to ensure fair competition in the market and thereby augment consumer welfare. With the rise in online platforms and the rapid shift to e-markets, competition authorities are also forced to recognize the significance of non-price parameters of competition such as quality, innovation, privacy, etc. Ensuring fair competition in digital markets poses far more challenges for the competition enforcement authorities as compared to the traditional markets. But the dynamic character of the markets and the constant emergence of new challenges also make competition law one of the most interesting areas of law for students as well as practitioners.
We were listening to the audiobook by the School of Management Studies IGNOU for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.